The question of if and when parents should be allowed to opt their children out of certain activities and curriculum in public schools has been raging for quite a while. With our society's rapidly changing standards, the need for parents to oversee and control the upbringing of their children has become even more important. Yet Montgomery County School Board decided that in one area of instruction, story time, parents of children as young as 3 years old would not be allowed to opt their children out of religiously objectionable material. Did the school board violate the First Amendment, or maybe another one? We'll discuss that next on the Constitution Study.
Love your neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach the rising generation be free. This is nothing new. The question of opt-outs and when they should be allowed, I remember dealing with it 20 years ago, back when I lived up in New York, and it's still raging today. This case made it all the way to the Supreme Court, and if you want to follow along with my resources, my links, well, you'll have to look up the written article on the website constitutionstudy.com. I'll talk more about the website and other things that are out there available there at the end of the episode. But for now, let's talk about these opt-outs. The length of oral arguments at 2.5 hours should give you an idea of the importance both the attorneys and the justices placed on this case. Because the amount of content covered during these arguments, this is going to be a long episode. We start with the questions brought to the court. Respondent, Montgomery County Board of Education requires elementary school teachers to read their students' storybooks celebrating gender transitions and same-sex playground romance. The storybooks were chosen to disrupt cis-normative and either-or thinking among students. The board's own principals objected that the curriculum was not appropriate for the intended age group, presented gender ideology as fact, shamed students with the contrary opinions, and was dismissive of religious beliefs. The board initially allowed parents to opt their kids out, but then reversed course, saying that no opt-outs would be permitted and that parents would not even be notified when the storybooks were read. Now, there are 2 points we need to keep in mind before we proceed. First, it is the right of parents to control the upbringing of their children. That includes both their academic and religious training. Second, while schools have some limited power in loco parentis or in place of the parents, when they are in school, that power does not supersede the parents' right to oversee the training of their children. Petitioners filed suit, not challenging the curriculum, but arguing that compelling their elementary-age children to participate in instruction contrary to their parents' religious convictions violated the Free Exercise Clause. Notice, the parents are not trying to change the school curriculum, but only be allowed to exercise their right to determine what is appropriate for the religious education of their children. Now, personally, I would have used a different argument for several reasons, but I'll get into that later. Ultimately, the question before the court is, do public schools burden parents' religious exercise when they compel elementary school children to participate in instruction on gender and sexuality against their parents' religious convictions and without notice or opportunity to opt out? Now, as always, arguments start with the attorney for the petitioner.
Mr. Chief Justice, and may it please the court. Parents everywhere care about how their young children are taught sexuality and gender identity. That's why nearly every public school in the country that provides sexuality education requires parental consent first. But Montgomery County is an extreme outlier, insisting that every elementary school student must be instructed that, among other controversial matters, doctors guessed at their sex when they were born, and that anyone who disagrees is hurtful and unfair. Forcing petitioners to submit their children to such instruction violates their religious beliefs and directly interferes with their ability to direct the religious upbringing of their children.
One of the points that will be brought up is that some parents objected to the curriculum for other than religious reasons. This is one of the reasons I would have argued differently.
The board claims this straightforward burden analysis will invite chaos, but schools nationwide have long applied expansive opt-out policies without significant difficulty. including the board itself, which still allows opt-outs for choir students who object to singing religious songs or students who object to certain storybooks, such as one that portrays an image of the Prophet Muhammad. Exempting students for some religious reasons but not others cannot be squared with the First Amendment.
This is the common and I believe flawed First Amendment jurisprudence currently enforced by our federal courts. This cannot be a First Amendment issue since Congress did not pass this as law. That does not mean this isn't a freedom of religion case, just that it does not come under the First Amendment. The decision of the Montgomery Board of Education to stop allowing opt-outs has had a significant impact on many families.
The board does not dispute that under its theory, it could compel instruction using pornography, and parents would have no rights. The First Amendment demands more. Parents, not school boards, should have the final say on such religious matters. I welcome the court's questions.
Before we get into those questions, I'd like to look at the other arguments. Next up is Sarah Harris, Principal Deputy Solicitor General for the United States, arguing in support of the petitioners.
Mr. Chief Justice, and may it please the court, when the government forces people to choose between violating sincerely held religious beliefs or forgoing a public benefit, that burdens religious exercise.
You'll find that this idea of burden is a recurring theme, especially during questioning. The First Amendment prohibits Congress from passing a law that prohibits the free exercise of religion, but how far can Congress go before it prohibits? The Merriam-Webster Online Dictionary defines burden as to load or oppress. By adding an extra burden to the exercise of religion, the courts have maintained that this is sufficient to trigger the First Amendment prohibition.
Here, Montgomery County offers a free public education to parents only if their children use books featuring same-sex relationships and transgender issues. That burdens parents of multiple faiths whose religious duty is to shield their young children from such content. Public schools routinely accommodate those burdens with opt-outs, which respect families of many faiths and backgrounds. Several states allow opt-outs from any learning material on religious grounds. Montgomery County allows many other opt-outs, just not here. I welcome the court's questions.
Montgomery County offers free public education. Actually, since these public schools are funded largely by local taxes, Montgomery County offers education paid for primarily by the residents of the county. As such, that makes it a public benefit. By denying said public benefit to people based on their religious beliefs, the county is burdening these families by requiring either that they compromise their faith or go somewhere else at their own expense. Also, since Montgomery County seems to be the only county in the state, possibly the nation, that refuses to offer opt-outs for this kind of instruction, and since the county allows opt-outs for other religious reasons, this seems to be a targeted attempt at indoctrination. As you might expect, the Montgomery County Board of Education does not agree. Representing Thomas Taylor, Superintendent of the Montgomery County Board of Education, along with the other respondents, is Alan Schoenfeld.
Mr. Chief Justice, and may it please the court. Every day in public elementary school classrooms across the country, children are taught ideas that conflict with their family's religious beliefs. Children encounter real and fictional women who forego motherhood and work outside the home. Children read books valorizing our nation's veterans who fought in violent wars. And children in Montgomery County read books introducing them to LGBT characters. Each of these things is deeply offensive to some people of faith, but learning about them is not a legally cognizable burden on free exercise.
Funny, I don't know many religions that prohibit being a mother or working outside the home. I do know people who prefer these things, and of course it is the tenet of the Roman Catholic doctrine to encourage natural motherhood. But does that give the state the authority to say children must be taught these things? The question isn't can the state teach these things, but can the state force these things to be taught and that they are right and good? Is this force a burden on a parent's free exercise of religion?
Adopting petitioners' view of the case would conscript courts into playing the role of school board, a task for which this court has recognized they are ill-suited. And a constitutional requirement to provide opt-outs from anything someone finds religiously offensive would mean public schools must find alternative classrooms, supervision for young students, and substitute lessons each time a potentially offensive topic arises. That is not what the Constitution requires, particularly given the special characteristics of the school environment.
Actually, that is exactly what the Constitution of the United States requires of Congress. Public schools already find alternative classrooms, supervision, and lessons for other religious objections, So why would story time be such a burden to the Montgomery County schools? Contrary to what Mr. Schoenfeld has said, the burden would be on the schools, not the courts. A simple, you must accommodate the religious beliefs of both students and parents does not engage the courts unless the schools refuse to do so.
This court has made clear that exposure to offensive ideas does not burden free exercise. And it has held that the government is not required to do its daily work in ways that make it easier for parents to raise their children in the faith.
This idea of exposure versus instruction took up a lot of time during questioning, so much so that I have an entire section on it later.
The books at issue here, 5 among hundreds in the curriculum, are meant to foster mutual respect in a pluralistic school community. MCPS makes explicitly clear that students do not need to accept, agree with, or affirm anything they read or anything about their classmates' beliefs or lives. The lesson is that students should treat their peers with respect. I welcome the court's questions.
Again, it's not the quantity of objectionable material that is the problem, but the forcing of students to consume it. As I mentioned above, the question of exposure versus instruction was a central topic during questioning. Let's look at some of the highlights.
Could you spend a minute or two to explain why the record shows that the children are more than merely exposed to these sorts of things in the storybooks?
No, we know that the teachers are required to use the books. When the books were first introduced in August of 2022, the board suggested they be used 5 times before the end of the year. That's at 273A in the CERT appendix. One of the schools, the Sherwood School in June, for Pride Month, said that they were going to read 1 book each day to celebrate Pride Month. The board's own testimony through Superintendent Hazel said that the books must be used as part of the instruction, and that at 642 in the appendix, that discussion will ensue.
It was not as if these books were in the school library or on classroom bookshelves and available to students. The board was not only suggested they be used multiple times in one school year, but one school made a point of reading them to celebrate Pride Month. That's a celebration of deviant sexual behavior, including parades and other events consisting of people in lewd dress, often engaging in suggestive, if not pornographic activities. Why did the board want this as a mandatory instruction?
That was the entire point of withdrawing the opt-outs and removing, even notifying parents. They're not even allowed to know. The board said in that statement it was so that every student would be taught from the inclusivity storybooks. And also the district court transcript at 63 has counsel's admission that some of the books have to be used and it can be more.
The obvious point was not merely to expose children as young as 3 to 4 years old to these ideas, but to instruct them to both celebrate and normalize them. Justice Sotomayor and Mr. Baxter got into quite an exchange about the topic of exposure versus coercion.
Let's go back. Is it generally that the mere exposure, haven't we made very clear that the mere exposure to things that you object to is not coercion?
It would really depend on the individual religious beliefs. Here, for example, our Catholic clients...
So what you're saying is that the exposure of children to the fact that 2 people are getting married is coercion? That 2 people of the same sex are getting married is coercion?
Justice Sotomayor sounds more like a prosecuting attorney on cross-examination than a justice of the Supreme Court. Of course, she was not the only one to interrupt Mr. Baxter, but you should get the flavor of this line of questioning. She also seems to ignore the fact that looking at pictures was not all that was included in this curriculum.
For reality's sake, you see interfaith couples all the time walking around. You see interracial couples walking around. You see women on this court in positions of work outside the home.
And no one here is raising a burden in that situation. We're far beyond that.
The point that both Justice Sotomayor and Mr. Baxter seem to miss is that there's a difference between exposure to something as you go about your business and being compelled by law and policy to expose your children to it. Furthermore, as we'll see, this is not mere exposure, but indoctrination, since the teachers were encouraged to both make these books part of the instruction and to correct those who disagree with their message. Take, for example, this interchange between Justice Barrett and Mr. Schoenfeld for the respondents.
this is an instruction to the teacher, if a student observed that a girl can only like boys because she's a girl, the board suggested that the teacher disrupt the student's either-or thinking by saying something like, actually, people of any gender can like whoever they like. Or on the transgender issue, when we're born, people make a guess about our gender and label us boy or girl based on our body parts. Sometimes they're right, sometimes they're wrong. When someone's transgender, they guess wrong. When someone's cisgender, they guessed right. So, it's kind of along those things, which seem to be more about influence, right, and shaping of ideas and less about communicating respect, because it's less about communicating respect for those, who are transgender, who are gay, and more about how to think about sexuality. What is your take on that and how we think about this, whether this really is just about exposure and civility and learning to function in a multicultural and diverse society, and how much of it is about influence, or as petitioners would say, indoctrination?
Certainly. I think what you've quoted, Your Honor, are suggested responses or proposed responses for age-appropriate ways to respond to questions that may arise in response to these texts or otherwise. The same response about disrupt the either-or thinking is given when someone says dresses are for girls, boys can't paint their nails, those are boy toys. These are simply ways of contextualizing the information that's being learned and to give students the predicates for being able to respect each other. The express directive from the school is you don't need to understand your peers, you don't need to agree with them, you don't need to affirm with them, but you do need to treat them with respect.
Except the expressed message directive from the school is that one side is right and the other is wrong. The instruction isn't, there are people who believe this and we should treat them the way we would want to be treated. Rather, it's promoting these agendas by claiming they are right and opposition is, by definition, wrong. To a young child, this is the equivalent of telling them their parents are wrong. How can that not be indoctrination? Justice Alito got into the questioning.
The book has a clear message, and a lot of people think it's a good message, and maybe it is a good message, but it's a message that a lot of people who hold on to traditional religious beliefs don't agree with. I don't think anybody can read that and say, well, this is just telling children that there are occasions when men marry other men. Uncle Bobby gets married to his boyfriend Jamie, and everybody's happy, and everything is, it portrays this. Everyone accepts this, except for the little girl, Chloe, who has reservations about it. But her mother corrects her. No, you shouldn't have any reservations about this. As I said, it has a clear moral message.
Wait a minute.
Yes, these books have clear moral messages, and contrary to what is being argued by Mr. Schoenfeld, this is not a case of mere exposure, but coercion and indoctrination into the message these books promote. Justice Jackson tried to come up with an analogy that would fit her understanding of the situation.
I'm just trying to find an analogous public benefit outside of the school context and ask you whether your position is that it substantially burdens the rights of religious parents if there are advertisements on a public bus that say things that they don't want their children exposed to.
I think a better analogy to what the schools are doing would be to consider how the parent instructs the child to deal with the advertising. A parent could teach their children to simply turn their gaze away from such advertisements, while the school is effectively saying, no, you must look because it's right. Justice Gorsuch brought up another point.
Correct.
Yeah, okay. And you've included these in the English language curriculum rather than the human sexuality curriculum to influence students. Is that fair? That's what the district court found. Do you agree
I
with
think
that?
to the extent the district court found that it was to influence them towards civility, the natural consequence of being exposed.
Whatever, but to influence them.
In the manner that I just mentioned, yes.
Yes, even the attorney for the board admits this curriculum is to influence the children. However, as we've seen, it's not towards civility, but acceptance. The Montgomery County Board of Education claims that they stopped offering opt-outs for this curriculum because they found it administratively unworkable.
Couldn't you solve those differences simply by restoring the opt-out?
Your Honor, I think in this case, the record makes clear that the school district did try to honor the opt-out, and at some point it became infeasible. Certainly there are circumstances where the right decision a school board might make in view of the particular needs of a community is to offer the opt-out. It's a different question from whether it's constitutionally required.
But during Chief Justice Roberts' questioning of Mr. Baxter, administration of the opt-outs didn't seem to be as big a deal as Mr. Schoenfeld would later state.
The school board alleges that the opt-out system became unworkable. Is that a factor we should take into account in deciding whether it could be required?
Certainly, there could be situations where it could be unworkable. The board never raised that until after this litigation commenced. When they announced the withdrawal, they said it was because every student needed to read the inclusivity books. When they produced documents in response to an open records request, there was no mention of it not being workable. When parents met with the superintendents, this is in the Hisham Garti declaration at JA 44. The reason given there was inclusivity. There was no mention of administrability until the litigation's been filed. And even then, all the board was able to come up with was an argument that in one instance, in one school, there were dozens of students who opted out, where if the average school size in Montgomery County is 700 students across at least a dozen classrooms, you're talking maybe one student per classroom. That hardly compares with the 1 in 8 students who are opted out for individual education programs. 15% of students in Montgomery County who are taking English for speakers of a second language. The board's own opt-outs that are required from the same instruction required by state law to be opted out when the same books are read in health class.
If the administration of these opt-outs was so onerous, why was it not mentioned when their cancellation was announced, in the documents produced, or even when meeting with the parents? Could it be that there's more to this administrative problem than meets the eye? Now, Justice Thomas dug into this a little deeper.
I think chatting with Justice Kavanaugh, you mentioned that the opt-out was unworkable because there were so many students who opted out. What do you mean by that?
So the record is limited on this point, but the Hazel Declaration talks about the fact that principals reported to the school board that there was high absenteeism and gave the example of one school where dozens of students were opting out.
Again, the problem the board saw that led them to cancel these opt-outs is the number of students opting out, which I think points us to another question. Why are there so many opt-outs of this curriculum? Could it be that this curriculum is so offensive to so many people that the only way for the board to teach this nonsense was for them to force it down the students' throats? That is not teaching respect and kindness for others, but totalitarian conformity to the government's views. Justice Alito and Mr. Baxter had an interesting discussion about age appropriateness.
What are the ages of the children who were involved here?
These books were approved for pre-K, which in Montgomery County can start as early as 3 if they're going to turn 4 that fall.
And it goes up to what?
The books that we've all talked about go through grade 6.
All right, so you're talking about children maybe in the age of 5 to 11 or 4 to 11. Now, would you agree that at a certain age, students are capable of understanding this point, which probably is not a point that can be understood by a 4 or 5-year-old, and that is that my teacher, who was generally telling me that certain things are right and that certain things are wrong, isn't necessarily going to be correct on everything. It is possible for me to disagree with him or her on certain subjects. Would you agree that there comes a point when a student is able to make that distinction?
That's right, and many of our clients' objections would be diminished as their children got older. But here we're in a situation where Montgomery County's own principals objected that these books were inappropriate for the age, that they were dismissive of religion and shaming toward children who disagree. The board itself withdrew 2 of the books for what it said were content concerns because it finally agreed that what parents and its own principals were saying was accurate.
Most of us would agree that there are topics that are not appropriate for children as young as 3 or 4 years of age. But who determines what those are? More importantly, how granular is that decision? Because while we are dealing with classrooms of children, each and every one of them mature at different rates. If it's appropriate for 50% of the class, is that good enough? Should the teacher be the one determining what is appropriate for a child of a certain age? Should the board? And what about the 50% of students who are not prepared to deal with a certain subject? Should they be harmed because the board wants this education promoted? Speaking of this education, why is the Board of Education working so hard to force children to learn about these subjects?
Yeah, and one final factor that may distinguish this particular case from some of the others that you have been asked to express a view about, and you did touch on this, is the fact that it concerns sex and gender, and that the Maryland legislature itself has recognized these subjects raise special concerns and has provided for an opt-out from the health classes where these matters are discussed.
That's right. And currently in Montgomery County, you can opt out from the very same instruction during health class, but then you're required to stay during story time.
Isn't that interesting? You can opt out of instruction during health class, but when the same subject comes up in story time, the board says no. Mr. Baxter pointed out an interesting incongruity in the board's argument.
And then also a question about when sex ed starts. The boards and the state's mandated regulation is in the record. It's at pages 62 through 83 of the joint appendix. There you start in pre-K with instruction that parents can, or families can come in all different forms with all different kinds of parents, different kinds of gender identities and expressions. The same things that are being taught through these school books, you can opt out when it comes up during health class, but not during story time, in which there's no instruction about how to use these books to develop characters, narrative arc, or anything else that you would expect in an English class.
The question of age appropriateness of starting sex ed in pre-K is one thing. Hiding it in so-called English curriculum is something completely different. Justice Jackson made an interesting point, but not the one I think she intended.
In that situation, I guess I'm struggling to see how it burdens a parent's religious exercise if the school teaches something that the parent disagrees with. You have a choice. You don't have to send your kid to that school. You can put them in another situation. You can homeschool them. How is it a burden on the parent if they have the option to send their kid elsewhere?
Talk about living in an ivory tower. Justice Jackson acts as if sending your child to a private school or homeschooling them is a simple matter. Apparently, she doesn't realize what's involved in either of those choices.
Well, Your Honor, the world we live in this case is that most parents don't have that option. They have two working parents. They
yes,
can't
as
afford
a matter
to
of
send a private
practicality,
school,
absolutely.
And that's the reality for our parents.
I understand, but in so many other constitutional doctrines, we don't focus on whether people actually can afford to protect their rights.
What's odd to me is that nowhere else is the right to protect your religious freedom from government infringement based on whether or not you can afford to do so. This court has repeatedly stated that you cannot be deprived of a public benefit because of your religious beliefs. But according to Justice Jackson, well, public school is different.
And what I guess I'm worried about is a world in which when there is an option to send your kids somewhere else, it seems to me that these parents would be dictating what this school does in the way that you say our cases say they can't do.
Tell me, Justice Jackson, will the parents who left Montgomery County schools because of their opt-out policy be reimbursed for the taxes they've already paid to support that school? See, it's not merely whether or not they can afford other options. They have been taxed under threat of fines and jail to pay for these schools. Justice Alito got into a similar discussion with Mr. Schoenfeld.
So you have a case where some of the plaintiffs are devout Muslims. They say, we have a solemn religious obligation to raise our children as Muslims, and that involves certain moral principles that we want to instill in our children, and this school is teaching our children moral principles that are in conflict with ours, and we pay taxes to support the public schools, but we don't have enough money to send our children to private schools, and one of us can't stay home and provide homeschooling. So we just want to be able to take our children out of the part of the instruction that we find objectionable. And what's your response to that? Your response to that is just, well, it's too bad, all right? This is the public school, and the public school can teach what the public school wants, and you don't like that? well, you can send your children to private schools.
There's no indifference to the religious beliefs of the petitioners in this case. The school did what it could to accommodate those views. There are simply circumstances in which what the petitioner or what any plaintiff recognizes as a burden on their religious belief is not a legally cognizable one, given legal and practical judgment.
Except the board never mentioned the administration of the opt-out until the lawsuit. And the main complaint regarding administration of the opt-outs is the number of people opting out. Does that sound like respect for the parents' religious beliefs? Not to Justice Alito.
Well, it's nice that you say that they respect the parents' religious beliefs, but basically your answer is it's just too bad.
I think my answer...
You've got to send your children to school. You can't afford to send them to any place except a public school. Unlike, most of the lawyers who argue cases here, they can send their children to private schools. We may think that that's the way most of the world is, but it's not. It's just too bad.
My answer is that public schools are democratically controlled for a reason. The school board here is democratically elected. The entire process of adopting this curriculum is open and transparent. These books are on review for 30 days before they're even made part of the curriculum. There's then a multi-level appeal process. There's plenty of opportunity for parental insight.
Except neither the United States nor the state of Maryland are democracies. They are constitutional republics. And this is a perfect example of why we are not a democracy. See, democracies allow the majority to overrule the rights of the minority. Simply because the majority of the people of Montgomery County chose board members who wish to promote a sexual agenda on children as young as 3 years old does not deprive their parents of the right of public benefit without compromising their religious beliefs. As Mr. Baxter pointed out in his rebuttal, this was hardly a democratic process.
This was not a democratic process, withdrawing these overnight, comparing parents to xenophobes and white supremacists. This can't be part of the democratic process.
Under Maryland law, parents are compelled to send their children to public schools unless they ask for an exemption. And now, when everyone else, religious or otherwise, is allowed to benefit from these schools, Justice Jackson and the Montgomery County Board of Education wants to bar the door, just as George Wallace did with the University of Alabama in 1963, simply because their religion does not promote this sexualization of children. How can that not be a burden on the free exercise of religion? Another concern that Mr. Baxter brought up was how the board treated the reactions of the parents.
Then complaints were raised, right?
That's right. Hundreds of parents complained. These were mostly, according to the news articles, mostly families from Muslim faith and Ethiopian Orthodox who were objecting when they spoke to the board. The board accused them of using their religious beliefs as another reason to hate, accused a young Muslim girl of parroting her parents' dogma, and then accused the parents of aligning with racist xenophobes and white supremacists. And so, again, there's no question in this case that there is a burden, that it was imposed with animosity, and that it's discriminating against our clients because of their religious beliefs.
Could it be that the board was less concerned about the administration of these opt-outs than the religious nature of them? After all, claiming that a young girl's parents are racist, xenophobes, and white supremacists because they object to their daughter being sexualized at a young age seems to be a deflection. The parents weren't complaining about the race of their characters in the book, but the lessons they were teaching their daughter. Justice Gorsuch got Mr. Schoenfeld to admit the board's bias against religion.
So you take the view that even if you have a non-neutral policy, and even if it was motivated by hostility toward religion, and even though the parents claim a burden, you still have to somehow meet an additional objective substantial burden test?
Correct.
As I stated at the outset, I would not have argued this as a First Amendment case, or even a freedom of religion case. As Justice Thomas found out during his questioning of Mr. Schoenfeld,
it was that because they found the materials objectionable or for religious reasons or what?
There are two different paragraphs of her declaration that speak to this fact. In that paragraph, it doesn't specify. Elsewhere in the declaration, it makes clear that many of the opt-out requests were not religious in nature, and parents objected, for example, to the age appropriateness of materials have nothing to do with religious prohibitions.
There are apparently many parents and even school principals who object to this curriculum for non-religious reasons. Should their concerns be ignored? To me, this is a parents' rights issue. The Montgomery County Board of Education is depriving these parents of their liberty to raise their children as they see fit, violating the due process clauses of both the 5th and 14th Amendments. Arguing this is a due process case rather than a freedom of religion case would have eliminated all the questions of sincerity as well as the concerns about entailing the courts in religious issues. Yet there's another issue to consider. It should have been obvious that it was illegal for government in the form of public schools to force instruction upon students that violate their religious beliefs of their parents. But when a school sees a large number of opt-outs, it should be a sign that there's a problem with that curriculum. Perhaps that signal should have been used by the schools to pull the curriculum, as Mr. Baxter stated.
And it somewhat flips the Bill of Rights on its head if we're worried more about extreme examples that don't happen to protect the government from the parents as opposed to protecting the parents' fundamental rights to direct the religious upbringing of their children.
I try not to predict what the courts will do. I can only hope they will protect the parents' fundamental right to direct the upbringing of their children. So finally, I think we get to the root of this Montgomery County Board of Education policy. It's not about exposing children, but about indoctrinating children. It's not about protecting parents' rights. It's about taking away parents' rights. It's about determining what children should learn and forcing that on their parents, whether they like it or not. The only thing worse than that was the response of Justice Jackson, as if taking your child out of public school for a private school or homeschooling is no big deal. I'm still baffled by that one. I guess we'll see how things go. The important point is you have rights, and while we have to wait to see what the justices of the court ultimately decide, at least the fight is on. And from the court watchers that I've heard, they seem to think the court's leaning towards the parent side in this case. We'll have to wait probably until late June to get the answer. But I hope you found this interesting. I know it was a long episode. That's because there was so much good content. I couldn't figure out how to break it up without losing the continuity between two sections. So I'm glad you stuck around. I hope you enjoyed this episode, long as it was, and I hope you'll come back and join us for some more. I also hope you'll head over to The Miracle of America. Go to constitutionstudy.com/1776 study guide. You'll be taken to a custom landing page for this great course on our history, basically from the Pilgrims to the drafting of the Constitution. Best of all, you can enroll for a lesson on God's natural law absolutely free. Just go to constitutionstudy.com/1776 study guide. That's the numerals 1776 study guide. And you can find out more about the course, read up about the instructor, and best of all, enroll for your free lesson on God's natural law today. In fact, if you like the course, you want to take the whole thing, it's just $17.76. But it starts at that website, constitutionstudy.com/1776 study guide. I also hope you'll head over to Patriot Mobile, America's only Christian conservative wireless provider. I joined them a few years ago, and I've been very happy since. Not only do I get great coverage and 100% US-based customer support when I need it, I know a portion of my bill is being used to support organizations that are working to protect my rights, not destroy our rights. Find out more by going to patriotmobile.com/constitution. You'll find not only more about Patriot Mobile, you can sign up for a plan, find one that works for you, maybe get a discount if you're a veteran or an NRA member, just a family with multiple lines. But be sure to use the code Constitution at checkout to get free activation. Once again, that URL is patriotmobile.com/constitution, and don't forget the code Constitution at checkout to get free activation. Whatever you do, I hope you enjoyed the program. I hope you'll share the links. Let other people know what we're doing here. Maybe they'll come and join us the next time for the Constitution Study.